Now it's time to focus on defenses in criminal law. And in torts and contracts and real property, we'll spend a great deal of time on a civil litigant's defenses. But here in the law of crimes, defenses are a lot more narrow and they're a lot more simple. And so I would consider the defenses to crimes to break down into two broad categories, those that involve insanity defenses and everything else. The insanity defense is regularly tested on the multi-state, although not in great depth, and it also can commonly be tested on the essays as well, all over the country. So what's the bare minimum you need to know about the insanity defenses? Well, I would say the bare minimum is you've got to be able to identify all of them, and you've got to know what the basics are. And believe it or not, the most common mistake that people make is they can't keep the different insanity defenses straight. And it's not really that complicated. So let's have a look together. The insanity defenses include Durham, the irresistible impulse test, McNaughton, and then the ALI model penal code approach. And the differences are simple enough that you can keep track of them fairly easily. The Durham insanity defense is where the defendant is acting as a product of a mental illness. The Durham defense could be called the product defense. So the defendant hasn't been able to conform his or her conduct to legally acceptable standards because the conduct of the defendant is the product of mental illness. And if this sounds like the most vague, most slippery insanity defense, you might very well be right. Then we turn to the irresistible impulse defense. Here, the definition is basically wrapped up right in the name. Here, the defendant has got a defense to a crime charged because he could not control his actions. And of course, if a female can't control her actions, she escapes criminal liability as well as a result of the irresistible impulse insanity defense. Next, we turn to McNaughton, and this is the most complicated of the insanity defenses, and it's not that complicated. So, with regard to McNaughton, here the defense has to show that the defendant either did not know that his act would be wrong, or the defendant did not understand the nature and the quality of his actions. All right, well, that's pretty simple. One other detail about the McNaughton rule that you need to keep in mind is the McNaughton rule does not include an irresistible impulse as an element of that defense. And then finally, we turn to the ALI model penal code insanity defense. And here, we've got a defendant who lacks the substantial capacity to appreciate the criminality of his or her act or to conform his or her conduct to the law. That's the ALI test. Now, we'll see how this material is tested when we get into the hypotheticals. And perhaps you will find that there's a detail or two about these tests that you'll want to add to the outline. But then again, maybe not. This material is easy to make more complicated than it really is. The most important fundamental thing you need to know is be able to call up the list of insanity defenses and have a reasonable idea about what the elements of those defenses are. If insanity is the most common defense, all of the other defenses also do come up on the exam, and all of them are somewhat more straightforward. Next, we consider intoxication. And intoxication falls into two broad categories: voluntary intoxication and involuntary intoxication. And the biggest difference is the defendant has got stronger defenses to crimes if his or her intoxication was not deliberate. So if we've got somebody who is at a nightclub and some other nightclub attendee dopes his or her drink, the conduct of the person who has been drugged, as opposed to someone who has voluntarily taken alcohol or other drugs, will be less likely to be convicted of a crime than one who has voluntarily taken drugs or imbibed alcohol. Probably the single most important detail to know about the intoxication defenses is this: voluntary intoxication can be a defense to specific intent crimes, but it is not a defense to general intent crimes. So, voluntary intoxication is not a defense to rape, because rape is a general intent crime. But it could be a defense to attempted rape, because attempt is a specific intent crime. And you'll see a fair number of complicated questions as you do practice MBE work in this area of law. And it's worth paying attention to, but I think you'll probably find that you'll make more errors based on a failure to carefully read than based on a lack of legal understanding. So have a good look and keep practicing. Another defense, which is generally overlooked but which can be tested, is infancy. And we know the younger a person is, the less likely they will understand the nature of their acts. Another big area of defenses is justification. And really, justification is probably close behind insanity in terms of how frequently it's tested. Justification boils down into a couple of categories: self-defense, defense of others, and defense of property, including defending one's own dwelling. And the rules here are a little different in each of the different scenarios, but the basic idea remains the same. One is entitled to use non-deadly force to ward off a non-deadly attack on oneself or on a third party. When one is defending a third party, the defender only has the right to use the same amount of force as the victim would have the right to use. Remember that non-deadly force is okay to prevent the commission of a misdemeanor. And in fact, non-deadly force, if you remember from the law of torts, self-help, is permissible when a defendant wants to reclaim chattels that have been taken from his person or presence by someone who is trespassing against those chattels or seeking to convert them. Also, remember that the defendant has no obligation to retreat so long as the defendant is using non-deadly force to ward off a non-deadly attack. So now, let's take a look at the use of deadly force. Lawful self-defense that results in killing the aggressor is excused. It's not a criminal act. But let's take it a step further. Suppose we've got someone who is defending himself or herself and who has the right to use deadly force, but some third party gets killed. So the bad guy is attacking the defender pulls out a weapon, fires a shot at the attacker, misses the attacker, and kills some entirely innocent third party. Is that a criminal act? Answer, no. Because the use of deadly force in self-defense was not itself a criminal act, the accidental killing of a third party is not a crime. Now, the victim or the family of the victim will have a tort theory of liability against the shooter, but it will be a tort theory grounded almost certainly in negligence rather than being a criminal law theory of transferred intent. So if a bad guy shoots at victim A, instead hits victim B, the defendant's still guilty of homicide because the intent to kill was not justified in the first place. Whereas if we look at this somewhat different fact scenario, where a victim has the right to use deadly force against the attacker and accidentally kills a third party, no criminal liability attaches because the shooting is justified. Now, let's think for a moment about another fairly complicated fact scenario. Suppose we've got a situation where the attacker uses non-deadly force. The defender responds with a disproportionately violent reply. Is it possible that that disproportionate reply to aggression can justify self-defense on the part of the aggressor? And the answer is yes, so long as the aggressor withdraws and communicates his or her intention to cease the attack. And under those circumstances, the initial aggressor is entitled to use deadly force. Now, suppose we've got a situation where the aggressor attacks the victim in a non-deadly fashion, and the victim suddenly and unreasonably escalates the defense to a level of deadly force. Is that a situation in which the aggressor, the initial aggressor, can claim self-defense? Answer, yes, but it's a somewhat closer call. And on an essay, you always will want to narrowly and specifically address the exact facts in the pattern, report on them like a journalist, and then explain them like a lawyer. Now, self-defense blends naturally into the defense of others. And remember, all I've said is that the defender of a third party has the right to use the same level of deadly force as the third party would do. Now, we consider defense of property, including the defense of a dwelling. Here there is a certain trend by statute to give the defender of a home a greater right to use deadly force than heretofore has existed. It's unlikely that that will be tested without giving you some hint about what the statute is. In the absence of a statute, one is not entitled to use deadly force to defend his or her home unless there is a threat of deadly force on the part of the person that broke in. Now, how about crime prevention? To what extent do we have the right to use force to prevent a crime? Answer: it depends on the nature of the crime. If we've got a third party who comes upon a scene where a rape is taking place, it's likely that the defender would have the right to use any type of force, including deadly force, to cease that attack. Again, we have to carefully examine the facts. Another infrequent defense to crimes is the defense of duress, where the real bad guy kidnaps number two and then forces number two to commit crimes. So long as the second person is truly under duress and reasonably fears for his or her life, that is a defense to crimes up to but not including crimes of severe violence. The more violent the criminal act, the less likely duress would be a valid defense. A very common defense is the defense of mistake, and we've touched on it already a couple of times very briefly. This is an area of law where you are much more likely to learn the material in a meaningful way through practice than through abstract study or listening to even the most skillful presentation by a scholar on this narrow issue. But basically, the idea of mistake is that mistake or ignorance of fact can show that the defendant did not intend to commit a criminal act. But notice that even a reasonable mistake of law usually is not a defense to a general intent crime, but it can be a defense to a specific intent crime. So here again, we see how important it is in the law of crimes to focus on the mental state of the defendant. Another defense is causation. Here the defendant admits the conduct alleged by the plaintiff, but denies that this conduct was the cause of the plaintiff's injuries. We've also touched a couple of times on the issue of consent. Consent can be a defense to many crimes so long as it is voluntarily given and that the victim has the capacity to consent, and so long as the defendant has not used any fraud or other misconduct in order to obtain the consent. Now, consent does have fairly specific boundaries. And we know, for example, that a child, a minor, does not have the power to consent to sex because they are below the age of consent. And we also have seen that statutory rape is a strict liability crime. So the defense of consent does not apply to statutory rape. Obviously, the consent defense is probably the most common defense to rape, and we have to allow the finder of fact to make a determination as to whether or not, in fact, the alleged victim gave consent at the time of the incident. And the final defense that I will touch on very briefly is not commonly tested on the multi-state, although it has come up from time to time on essays, and that's the entrapment defense. Entrapment. And this defense has narrowed somewhat over the years, but it has never been a very broad or a very strong defense. In order to establish an entrapment defense, the defendant has to show that the entire criminal conspiracy, the entire design of the crime, originated with law enforcement as opposed to originating with private citizens. And most difficultly, the defendant has to show that he or she was not predisposed to commit the crime. Here again, we have to carefully examine the facts. And that wraps up a discussion of defenses to crimes. Obviously, this material is somewhat more complicated than a 15-minute presentation would suggest, but this is an area of law that is not heavily tested, but it is an area where there is a fair amount of detail. The best way to learn that detail is doing a high volume of practice.